Hello, my friends. We are live. It's Bradley J. and my friend Michael Coyne, the Dean of the Massachusetts School of Law, whom checks in from time to time. How do you do?
I'm doing well. How are you? Enjoying your summer, I hope.
No, not at all. It's way too hot. Really, I mean, it's better than not having a summer, but still, it's a little bit too hot. So we planned this before the most recent shocking events regarding President Trump and Mar-a-Lago, so that this will definitely have an effect on what we talk about today. And I want to jump right into it. So the first thing is that the the Justice Department is going to know that this is going to create a political firestorm and inflame Trump supporters and cause all kinds of problems. And I'm sure they weighed, look, is this worth it? This had better be significant, and it better be not just a fishing expedition. So, my first question to you is, what does it tell us that they went ahead and did this? Folks, if you just crawled out of a cave somewhere, a search warrant was executed on President Trump's Mar-a-Lago home, and it can't be just a an attempt to tie up loose ends and get these documents that are scattered around there. There has to be something more going on with knowing the consequences of this thing. There must be a real serious reason to go ahead with this. It has to be more than just cleanup. What might it be?
Well, let me, before we launch into what the evidence would likely have to be and what the process is, but let me say this, because I know a lot of people feel it's politically motivated, they're out to get him, and a lot of that, and they have very strong feelings in that regard. And what you really need to know about the justice system generally is the rich and the powerful benefit from that status. It isn't a detriment to be either rich or powerful or have friends in high places. It should be, but it's not. And so, this whole argument that because he's rich and powerful and represents such a large constituency, that's why they're going after him. That's inconsistent with the justice system, because the poor, the people who don't have power, the disenfranchised, they unfortunately far too often are the people in our justice system who don't see as much justice as others. So understand from the first point is that he is not without his friends, as everyone understands, and he is probably still one of the most powerful people in the world. So the government can't and wouldn't come after him unless it had significant evidence, because the process for obtaining a search warrant demands that. This isn't a rubber stamp process, and no judge or law enforcement personnel in the world would be foolish enough to be signing things under the pains and penalties of perjury and then not making sure that the I's are dotted and the T's are crossed, that there is evidence, probable cause, to support the fact that a crime has been committed. And that's the process that has to take place here. So, law enforcement, likely the FBI, has an awful lot of evidence presently. And what they wanted to do is go further with their investigation and case. And so they had to seek permission from a federal judge or a magistrate to actually undertake the search, as the Bill of Rights requires. And no judge in his or her right mind would sign off easily on a search of a former president's home, especially a president who has such a pulpit as this one has. And so the process would have been very likely very carefully followed, and that it isn't just, in all likelihood, a bare bones probable cause situation. The likelihood is that they presented, in order to obtain this warrant to take the next step, a massive amount of evidence indicating that the president likely has committed a crime. And this one it appears to focus on the classified documents, the presidential records, papers and documents and things that belong to the government and not the former president, even though at one point they might have been considered his personal papers.
I would think that the Justice Department would do everything they could to avoid this for a number of reasons. One, it's going to cost so much work. It's going to be very expensive, and they're already really busy with the January 6th thing. I believe they've had to hire extra folks, and this is just going to put more burden on their system, cost them a lot more money. Plus, Republican lawmakers are calling for a review and saying there's prosecutorial misconduct and all. So they really had to know that it's going to be a real problem when they do this. And I would think they would have tried to avoid it at all costs.
I think the politics is actually helps the president, the former president, under the circumstances. If this had been Bradley Jay, who worked in the naval office or something else, and had taken classified documents or taken documents belonging to the government, the likelihood is this would have been a quick and relatively easy path to indictment and ultimately some form of resolution by Bradley Jay. The politics benefit, I believe, the president in this regard. And I think it also then raises the issue of will he run? And I think he will run on the basis that he's got more power and that this gives him the benefit. But the problem is that if in fact he has taken classified documents, if he's taken government property, there is a provision within that statute that if convicted, at least on the statutorily, would prevent him from running for office. And so that's obviously, if you were he or his supporters, that would be a concern if in fact he's abused the office by taking documents that belong to the government. That's another twist to this whole thing. But there's a simple way to resolve some of the issues about, is this political? Is this justified? What evidence did they have to take such an extraordinary step? The search warrant is served on the individual, and when the search warrant then is executed, as they did at Mar-a-Lago, they ultimately then provide an inventory of all the documents they took pursuant to that search warrant. So, excuse me, the former president, could release the search warrant so we could see on what basis it was issued, what the facts are that would support it, what charges that they believe they would uncover evidence to support, and then also what documents were taken and what information they seized as a result of the execution of that search warrant. And that's a pretty simple process, and that could be done today if they chose to release that, to show either that there was no justification for it whatsoever, no evidence to support such an extraordinary step, or as the government, I'm sure, would indicate, the FBI and the Department of Justice, is that there was ample reasons to have to undertake such activities, even though they recognize that it would have significant fallout. But at the end of the day, if there are classified documents that are at Mar-a-Lago, if there are other confidential government records that were taken that were not supposed to be, then in every case, almost every case, the government treats this as a very serious offense. You know, a couple of years back, I handled a matter for an individual in Massachusetts who had a secret clearance. He worked for one of the defense contractors, and they sought to remove his classification, which would mean he would no longer be able to work. Simply the reason that they thought he didn't deserve that type of clearance any longer is because he had family members living in a foreign country. The government has always consistently treated these pretty seriously. He's not the first person to face such inquiry. General Petraeus did, others have in the Clinton administration as well. This is something that's important to the government. It's important to our national security as well.
In general, the Justice Department does not issue statements as to why they did something. Usually they just speak through their formal actions. But in this case, there is a clamor for an explanation. So do you think they would have waited till the very last minute, as close to an indictment as possible, so that the indictment itself would be the explanation?
You know, you and I have had similar conversations in the past like this, and you'd almost think the answer should be yes. But geez, how many times have we said we must be close at this point?
Right.
January 6th is how long ago? There's other civil and criminal actions still pending in New York and Georgia, and they seem to drag on endlessly. So I think it's just speculative to try and say, well, we must be closer to the end now, which we can say, but closer to the end is one thing. Close to the end, I don't think we are. I think this is a process. The Department of Justice is notoriously tight-lipped about their investigations and when things would be done. I think this is consistent with that. I think based on the process likely needed to obtain the search warrant, they do have massive amounts of evidence at this point, so they could seek an indictment if they chose, in all likelihood. But part of that would be based on what they found over the other day as well at Mar-a-Lago.
So I agree with you that this is working in the former president's favor, because his, maybe his fire was starting to wane a little bit, but now there are people outside Mar-a-Lago with the flags, and his fans are righteously indignant in a loud way, and he's fundraising again. He's using it to fundraise, so it does work out. What are you able to glean about what documents may be in question?
Well, the speculation is all over the place with respect to this. And some of them are probably likely just simply presidential records that he may well have taken for as mementos. I like my little trophies from time to time, places we go, competitions the students may engage in, and the like. And so some of it would be mementos to remember important times. But others, it appears to go well beyond that with respect to the records and the previous administration's failure, as a general matter, to retain important records. And so I think some of it are likely to be secret or classified documents, simply because they've shown a reluctance to protect the historical record. And that's what a lot of this is for. The National Archives want to be able to show our history and how we reacted under certain circumstances and what we did and why, so that that information is preserved for all of time. And so it really does become a question of, well, we don't know what could be in there. We do know that there were about 15 boxes that were improperly taken and returned at one point. The question is there more? And I even saw a tweet from the president this morning about, well, the FBI hopefully didn't plant documents at Mar-a-Lago, which that sounds really dubious. My guess is that they were filming while they were executing the search warrant. And I don't think people think about planting drugs or planting evidence unless they're concerned about what might have been discovered during that search. It's very dubious of a proposition based on the protections that were likely taken during the search in order to rebuff such charges that might come down the road.
Seems like you feel it. It's just kind of housekeeping. And hey, Donald, you forgot to return those doodads, the snow globes, so that paper over there signed by so-and-so world leader that you wanted to keep your hands on. You don't think there's anything more nefarious that's underlying this?
I think I don't think that's the right way to characterize it. I think even if they're relatively routine records, that would be a violation of the act, in that documents must be preserved and they belong to the government. I think the likelihood is for someone to take them, they are not just routine records of ordinary activities. They are likely records of extraordinary activities and perhaps even classified documents that do not belong in private hands. And we do know that the former officials in the former administration have an awful lot of contacts with foreign governments, the Saudis, the Russians. I mean, Manafort came out and said the other day that, yes, he was providing confidential information to the Russians, not on the president's behalf, but on his own. There are a number of people in the administration, General Flynn in Turkey, that had significant contacts with foreign governments that would be of great concern if, in fact, some of these documents are secret or top secret or classified documents that somehow found their way out of the White House into Mar-a-Lago and potentially into foreign hands. Those are very serious matters. One could argue that they could be seditious conspiracy charges. There could be all sorts of significant criminal charges if, in fact, those documents are significant that they found in the safe and the like. I think even relatively routine documents are problematic, especially when already called to account for returning them. If they still haven't been returned, now we have a real problem that it will likely result in an indictment.
The president could have avoided all this simply giving them back, right?
Yeah, if everything, well, yes, giving them back doesn't negate the fact that you took it, that you committed a crime, but it likely means that there would be no indictment or prosecution if, in fact, all of it was returned. It's a good faith mistake. I believe that it's a defense if they're related to his election or that they're truly personal papers that would not violate the act. So you'd have a stronger defense, and the argument would be, once notified, I returned them all. If there are things that are still there, especially depending on their classification, that would be incredibly problematic for the president. And, then the question is, what if he is indicted? Can he still run? Yeah, he can run until he's convicted, and might well be exactly the way this ultimately plays out, because he's got the best pulpit. He's got the best argument that it's politically motivated if, in fact, he's a candidate. So this may push him even further in the direction of running for office, so that he can protect his hind quarters here.
I agree with that 100%. I don't think he would have run otherwise, because the number one thing the president hates is losing. And I think down the road, if the polls showed things weren't great for him, that he would not run. But all that's going on with the January 6th committee, etc., and the information that it brings out, it pushes him into having to run because it gives him some illegal cover. So that's unfortunate. That's the way things are. Hey, they would never actually arrest him, would they? And if they did, if they ever did, would they consider him a flight risk and deny him bail?
Yeah, you want to see the perp walk, huh? You want to see that?
No, that's camera, because I think that would only help him. I really don't. I don't think that's helpful. I think he would love that. He would love it. So no.
Oftentimes, and especially powerful, wealthy individuals are given the opportunity to surrender through their attorney and the like, and that would certainly be the case here. This would not be a 2 or 3 a.m. raid and parade him out in his underwear. But then you'd love all of this humiliation. But the fact is, if he is indicted and arraigned, there would be the question of bail. It's an interesting question, but I think when you look at the factors that bail generally looks at, the flight risk is there, obviously, but the connections to the United States, the fact that he has a number of people who would vouch for him and his integrity, that would indicate the likelihood that it would be a relatively modest bail. But relatively speaking, I mean, if he's a billionaire, it still could be a high bail. But does he have the ability to be a flight risk? Absolutely. And part of it would depend on the severity of the charges, right? I mean, if he's facing a charge of that the sentence would be a year or two in jail or whatever, that's a not significant consequence that someone might flee for. If you were facing, one of the seditions or some other type of charge here that could result in for a 70-plus-year-old man spending the rest of his life in prison, then you certainly would be looking at someone who potentially is a much bigger flight risk, and that would indicate a higher bail as well. So part of it is the charges, but part of it is, when you look at, does he have significant contacts here? He's lived here all his life. He's in the 70s. He certainly has a lot of money, but a lot of defendants have money. And the question would be the severity of the charges and what the risk is.
Does Merrick Garland and his department have to worry about any charges of prosecutorial misconduct? Is that something that's going to, be bothering them, or is that just too far flung?
No, I think that that's obviously a worry, and especially if you think of how contentious everything is within our government right now. The next election could change the construction of the House and the Senate, and the Republicans have made no bones about it. If they're in charge, there are going to be extensive investigations and inquiries made. So you would, especially if you were Merrick Garland and the Department of Justice right now, you would be double checking everything to make sure that your actions are as bulletproof as possible. Because no matter what you do, 30% of the country is going to say that it was wrong and politically motivated and unjust and unfair. So you've got to make sure that it's a belt and suspenders approach, that everything is beyond reproach, and that every action is defensible. It actually, and I know people don't necessarily, or everyone doesn't necessarily buy it, but all of those things likely means the evidence is that much stronger against the former president than it would be against anyone else, simply because that politically motivated is going to be one of the defenses to all of this. And certainly it will be, in the court of public opinion, the argument that's raised and advanced. And again, it's got a receptive audience for probably at least 30% of the country. So the likelihood is, such an extraordinary step. No former president has ever been subject to such an inquiry. And I know that is bothersome to many. But the fact is that no man is above the law. No one is. Not former presidents. No one should be. And that's important to all of us that support the rule of law. It's not, we're not a dictatorship. We don't have a king. We are a system of government and laws. And those laws are supposed to be evenly enforced and to protect us all. And so I know where we are right now is a pretty dysfunctional place all in all. But the question is, at the end of the day, isn't our democracy worth it, even if it's really, really messy as we go through some of this?
About executive privilege and using that to avoid answering questions, seems like that gets abused. Why is executive privilege invoked so often? It should only be allowed if the thing in question is a matter of national security. Anything else, it seems, should be on the table, especially if we're talking about potential crime. Can you talk about why they are allowed to use that so extensively?
In the law, in the legal system, privileges, all sorts of privileges, are generally abused and overused in order to prevent the disclosure of information. So it isn't just your executive privilege, it's the attorney-client privilege, it's the Fifth Amendment under certain circumstances, it's spousal privileges. All privileges are used in an effort to prevent the disclosure of what is likely not just relevant information, but highly relevant information, under the theory being that privileges protect the relationship and they protect our system that we might have and the relationship with each other. That's more important than obtaining what is likely relevant information. And so courts tend to err on the side of overprotection of the privilege. When we get to executive privilege, the Supreme Court has looked at this and looked at it again in Watergate, if you remember as well, because Nixon was claiming executive privilege on a whole host of matters there as well. Most of that, Watergate dealt with his reelection, not something as serious as an overthrow of the government or invalidating the election as January 6th was. But the executive privilege is a protection that the Supreme Court has looked at in the past. And in Watergate, sort of cut it back a little bit. But the bottom line is, shouldn't the advisors to the president and the president be able to seek counsel without fear at a later point that information would be disclosed, just as if someone faced an armed robbery charge and wanted to discuss the details of that with their attorney, and that during those communications to not have any fear that information would subsequently be disclosed. And so the answer is yes, we want those relationships to take place. We want those communications to take place. Hopefully at the end of the process, we have a better result. But lawyers can be a mischievous group as well. And so there are times where these privileges, one claims them in order to protect the information more, to hopefully slow down the process and maybe get the benefit of a judge saying, no, that's going to fall within privilege and not disclose it. And also, the longer it takes to get access to the information, the more fights we have about disclosure of the information. And you can see that with the January 6th committee. You can see that with the New York Attorney General inquiry here, the New York criminal inquiry. I saw Senator Graham is opposing the court's requirement that he produce information and testimony. The fact is, the more costly it is to get access to it, the more time it takes. Either someone might give up, or you might get a favorable ruling from a judge, meaning you'll never get it. Look at Alex Jones the other day. He was claiming part of it is privilege, part of it is yada yada yada, and then his attorney turns over the information, likely that had been requested years before, and what we found is hidden within those records that should have been disclosed ages ago. Was important, relevant evidence to the parents of the Sandy Hook victims. The discovery and privilege is where a lot of the shenanigans take place in my business.
So moving into the larger picture, I've wanted to ask you this question for a long time, and that is, which of the undisputed actions of the president constitutes a crime? It's not disputed that he made a phone call looking for votes. Why is that not in and of itself slam dunk a crime? Here's the call, boom. Are there any other things like that are actually undisputed actions that are a crime? And what might the crime be, and what might a penalty be for the crime?
I agree with you on the Georgia situation. Again, it's one when we look at, we know what the facts are. Doesn't really make sense why it's taken this long to really have no firm result in that case. There are questions about and not real questions, but based on the facts, why aren't any of the people who were present at the rally on January 6th, who incited the crowd to go to the Capitol and storm it, why Eastman, the president, the former president himself, why aren't these people, based on the video available, based on the actions we know that took place, why aren't they facing some of the same charges that those who were at the Capitol and have been indicted and sentenced at this point, that they have faced and are serving time for? frankly, that's beyond me. That some of those actions have not resulted in criminal charges there. There's a question about the whole action about the wire fraud, the raising the money, the stop the steal election, and the $250 million that was raised, that was pledged to fight in court and elsewhere the election fraud, when the evidence at this point appears pretty strong that numerous people within the administration knew there was no fraud. And even the president himself knew it wasn't fraud, but knew he could work with the set of facts. To me, there may be some relatively basic wire fraud charges there that could be pursued relatively easily on the basis of what we know. Again, I think the politics is holding up some of those, what are relatively straightforward violations. Again, if you or I committed the same acts.
Here's another one. Asking that the metal detectors be turned off so that armed rioters could storm the Capitol of the United States. Like that attempt to turn off the metal detectors to allow the weapons and the people, that seems pretty straightforward, not disputed. Wouldn't that be another one?
Yep. Well, multiple individuals have been charged with seditious conspiracy because of their acts on January 6th. Turning off the metal detectors certainly gets us awful close to that. But doesn't it at least get us close to the charge of interfering with the acts of Congress, which would be to certify the election? And so the interference requires a lot lower showing. But when you think about the rally, you think about turn off the lie detectors when you know the lie detectors. Yeah. Turn off the weapon detectors and allow folks an easier access who have weapons to the Capitol. Again, I think any other individual or individuals who aren't powerful and rich would certainly have faced charges. And I don't understand how that doesn't bother more people here, by the way. So all of the folks who acted likely in good faith, believing they were doing the president's bidding and doing the what the president of the United States had either ordered them or really asked them in strong terms to do. All of those folks, the regular workers and the like, we'll call them, they're either in jail, facing jail, or their lives have been transformed as a result of this. But all the higher ups, all of the rich and powerful people, the Roger Stones, the Alex Jones, the President Trump, the Meadows, other folks in the administration who orchestrated the entire day, face no real penalty even today, how many months after January 6th. What I don't get is how ordinary, middle class, regular people who work for a living can empathize with the group that's in power who orchestrated this and not recognize that the rich and powerful, again, are getting away with murder while the poor people suffer in our justice system. I don't get that part at all here.
Right. You do hear no one is above the law, but that's not true at all.
It's not.
We're looking at a lot of people that so far are absolutely above the law, and they know they're above the law, and they continue to behave in that manner. Okay, you mentioned, and I guess it's important to get to Alex Jones. You mentioned Alex Jones. You must have watched that, being the dean of the Massachusetts School of Law. By the way, this is Michael Coyne, dean of the Massachusetts School of Law, and you saw some clips, at least, of Alex Jones in court and his behavior. It almost seems like the dude is incapable of anything approaching the truth. It just doesn't. It doesn't register. And it's the same way. And maybe he can't help it with the former President Trump. The truth is not even a thing. And Alex Jones in court under oath with the judge right there saying, "Look, you're in court. You have to tell the truth." So, two questions: what are your overall thoughts about his behavior, and why is he allowed to get away with that time after time again? It seems like pretty obvious to folks that he perjured himself repeatedly. Why haven't these charges popped up?
The truth doesn't make him money. The truth doesn't make a lot of people money, and so they sell the lies. And that's
Even
that's
in court,
again,
even under oath, just you
even
can't stop
well,
the the lies
if you're
spewing
if
forth.
either you're doing it because you're motivated by money or you're a pathological liar, and both are probably the case with Alex Jones. The fact is that, as you said, even when the judge said you've already lied twice in court today, you're not on your radio show, you have to stop. He couldn't help himself. That whole thing. And why, again, does he avoid it? Because he's got lots of money, lots of lawyers. And if the government were to bring a perjury charge, his lawyers and he would tie them up in knots so that all the drug-related crimes and the family abuse situations, they wouldn't be able to do that. So they look at it as a cost-effective strategy. You let him avoid a perjury charge. Hopefully, the $50 million that will ultimately be received by the parents will make a difference. But a lot of times people like that, that's the cost of doing business at the end of the day. They sell the lies, and unfortunately, there's a significant population out there who buy into it and are going to make them more money tomorrow. So, I'd like to tell you that, and Alex Jones is an extreme example of it, but there are a lot of people that come into court and think they're smarter than the judge and the jury and the lawyers, and that they can spin a yarn and people will buy it. Sometimes people will, but more often than not, they see through it, as the jury ultimately did. And thankfully, because people shouldn't be able to benefit from their abuse of the system and their abuse of the public generally. And that's what he has done throughout, and it works for him, right? At the end of the day, you go with what works for you, and it has worked for him for ages, is to bluster and bully and to tell his lies, and to have an audience that buy into it. That's the really sad part here, is that they likely know. He even admitted, yes, that Sandy Hook, as you would have to, was real, but it shouldn't take you coming into court and being put under oath to admit that the tragedy that you profited from for years now, you've been just selling lies to an audience that trusts you. We live in bizarre times, I think, when I think about some of these issues at times.
Couldn't he? So 50 million seems like a lot, but for him, it's not a lot at all. He could have just settled for probably less than that, right? Why didn't he settle? What is the advantage for him of going to court?
Because I think you can continue to peddle your lies and your conspiracy theories. The judge was out there, and he did that even during the trial. That came out during the trial, is that he talked about the judge's involvement in pedophilia and showed her on fire. And just, the fact is that once you abandon the truth as a necessity, you can virtually do anything you want. And that's where we are with a lot of this. The election was stolen. Well, former Attorney General said it wasn't, and there was no evidence to support it, who was, by all accounts, a loyal Trump Attorney General through thick and thin,
right,
and ultimately resigned. Many others obviously see that was just not true at this point. But there are others still that continue to peddle non-supported information because it helps them raise money, it helps them obtain re-election. Liz Cheney, to me, is a great example. She tells the truth. She does what we would expect a patriot to do, is to really try to uncover the information so the public is informed. And the likelihood is she's going to lose her battle for re-election in Wyoming, because there are still people see her as a traitor as opposed to a true patriot. And our politics don't necessarily match, but I recognize, like I did with Elliot Richardson and Archibald Cox during Watergate, is that personal conviction and adherence to your constitutional oath are what sets us apart from all of these third world countries.
She may run for president, right? That would be
Yeah,
something.
I could see that. And I don't know enough about her, but I do know that she certainly has more integrity than most politicians these days, from what I can see. Even at a significant personal cost, because a lot of times re-election is all that matters to these folks, and that doesn't seem to be really factoring on her radar screen, because she knows many of her constituents have bought into the stolen election argument.
Right. I would think the campaign advertisement from her father would be damaging to Trump. There's no one more rabidly conservative than Dick Cheney, and the way that was set up with the way he delivered it with a cowboy hat. I mean, how does that not have an impact? She's not going to win, but that kind of thing could definitely set her up to run for president. It's like, and it could be damaging to Trump overall, I'm thinking.
Yeah. Well, see, and I agree with that. I mean, again, not sure, based on the vice president's former 8 years and the like, that I'm a fan. But I do understand the argument that we're being falsely led here, and people are just buying into it. I mean, I'm surprised that there aren't more long-established Republicans that aren't standing up for what Cheney is trying to do and what the committee's trying to do, because it really is about educating the public here. I don't think that the Democrats don't want Trump to run. I think him running would be a benefit to them. So I think that argument that they're trying to damage Trump as a candidate, I think the January 6th committee has released enough information now that we now can see what was going on during that period. Remember, Trump lost the last election before all of these problems with January 6th.
Right, that's right.
His involvement with it. That has not gained him any additional votes should he run for election during the next cycle. If anything, that has solidified those that were opposed to him, and likely changed some of those folks that are the 40% in the middle that could take it or leave it, with saying, well, we're not going to go through that again. So I don't think that that's a legitimate charge. I think there are other likely more viable Republican candidates that could defeat the president. And I think the Republicans know that, but they don't want to anger Trump.
Do you have time for two more questions?
Sure, absolutely.
Yay. Back to Alex Jones' trial.
Yeah.
I'm surprised. I felt like the judge didn't really have control. I mean, yes or no, she would say yes or no. He would completely ignore that. Wasn't he contemptuous of the court enough so that she could have thrown down the glove or whatever?
It's a delicate balance, and a lot of witnesses do the same thing. A lot of judges will say, well, answer it yes or no, and then you can explain. It's not uncommon, and it's also, though, the jury sees that. And here there was, so they can see what's going on, and they can see that you're trying to avoid answering the questions and the like. A lot of witnesses try to be evasive, try to be abusive, and he's acting perplexed. Well, he doesn't understand this or that. I'd like to tell you he's an atypical witness, but a lot of witnesses, that's, we teach that in law school, to try and control and confine the witness, to ask questions that are relatively narrow, so that you can elicit the testimony without getting, the full explanation and the like. But it is an art. I wasn't crazy about either lawyer in that case. But I did think, I thought the judge did an okay job recognizing that there's going to be an appeal when you're talking this type of money, no matter what. And so she had to try to be careful not to appear to really dislike him, as I think she did based on some of the comments. Because if someone lies to you in court, and lies more than once, there's a jury instruction that if a witness has lied, then you can disbelieve their entire testimony.
Mm-hmm.
But just one little lie if you found that they lied. And I think, especially with judges, they feel the same way. If you're lying and you're caught lying, than the fact that you're not a credible witness. When you're the defendant, then who does it? Then what you're likely looking at is a big judgment against you, and that's just what happened. I mean, we're talking about, $5 million in general damages, $45 million in punitive damages. That's likely going to be able to be sustained on appeal because punitive damages generally have to bear some relationship to actual damages. And a 10-to-1 figure is not really excessive. Close, but not excessive.
Is it ever the case that a person like Alex Jones would bait the judge with that kind of behavior, hoping she might take some action, which would be valuable to him upon appeal, which could be used against the judge, trying to draw her into some action that he could point to during appeal and say, "Up." Is that a strategy?
Absolutely. Remember, the whole point of Alex Jones's strategy in that whole case was delay and drag it out and not turn over information. I tell my students, every day the defendant keeps the money in their pocket is a victory for them. So the fact is that if he can delay it a couple more years, 3 years, whatever, on appeal and the like, that's another victory for him. He's kept his money that much longer. So absolutely, someone like that, and not just someone like that, sometimes attorneys try to do it improperly, is to bait the judge so that there's an overreaction. And that's that would not surprise me at all. I think he also lies because he's a liar. I think that's who he is that he can't answer a question directly. In that regard, that's where I think the plaintiff's lawyers took a slight misstep. I think while you had him on the stand and he's saying, well, you're saying you didn't get my phone records, but you got them. You're talking about them now. I would have asked the question, and you intended for us to have them. And the reason for that is, see, now they're trying to make the argument, they were inadvertently turned over. I should get them back. I think he would have said, no, I wanted you to have them. And then that would have made this whole argument about attorney-client privilege on those documents and inadvertent disclosure. It would have made it irrelevant because I think he would have lied and said, no, I wanted you to have those, because he's a liar.
And a final question.
Okay.
Back to President Trump.
Yes.
There's this notion that you have to knowingly break the law, but that's pretty gray. For example, the case could be made that he acted in a manner consistent with him actually believing that he had his election stolen. At what point does that not carry water anymore? At what point, after you've been told by multiple people, your own people, the experts in the field, 10 people, at what point does I thought I was acting because I thought the election was stolen, at what point does that not flush anymore?
You don't have to knowingly break the law because not everyone knows all of the laws that exist. What you have to have is the intent to do whatever the act is that would violate the law. And so if his intent was to interfere with the legitimate function of Congress and undertook actions to do that, which I think he did, then in essence you violated the law. The fact that you believed that you actually won the election is in many respects, to me, irrelevant to whether you took acts to interfere with the acts of Congress or whether you conspired with others to upset the election. The argument that, well, I really thought I won, when you're then facing all of your advisors, all of the other actual evidence that indicates otherwise, you can't still blindly follow what you believe, because now it's really a question of reckless indifference, that you're recklessly being blind to the actual truth. That doesn't give you any protection simply because you want to stubbornly adhere to something that's in your interest. I think it's the intent to do the act necessary that would violate the statute. Not that the likelihood is a lot of these folks probably didn't even know such statutes existed that they were ultimately charged with and convicted of.
They say willful ignorance is not a crime, but is it?
Well, sure, absolutely is. By the way, and I'll give you an example with respect to you can be guilty of murder because of your grossly reckless actions. Murder, not we're not talking manslaughter, we're talking murder. If you undertake grossly reckless actions and someone dies as a result of it, whether you knew that would happen or not, you are guilty. And so, no, it absolutely does matter, and it makes a difference. And the fact is that people at times do things without truly knowing what the consequences of those actions are, but a lot of time or appreciating the consequences of those actions, and a lot of times those folks end up in jail.
Well, today was great. As always, we've been talking for 50 minutes. It's 5:00, and I know you're pretty busy. I don't know how busy you are in the summer, but you're generally pretty busy. And I really, really appreciate the time. As always, Dean Michael Coyne, Dean of the Massachusetts School of Law. I always ask, what's the status of school now? What is it, August?
Orientation begins on Monday. We start a new semester on Monday. So our summer is rapidly coming to an end. So orientation week, then the following week we start classes. So we're just about right back in the thick of things.
Do you do a welcome speech to the new students?
Yep.
A big assembly?
We do an orientation where I talk to them. I don't do the Wilfred O'Leary from the Boston Latin School welcome we got in the 7th grade. Look to your right, look to your left. One of you will be left.
You got that in 7th grade.
Oh, yeah. Yep. And it was in a beautiful auditorium surrounded by the names of all the great Bostonians in the world that went to Boston Latin. It was really impressive. Dr. O'Leary was very impressive. I always say Boston Latin School is one of the best educational experiences in my life.
So what does your speech entail?
My speech probably steals a little bit from Dr. O'Leary. One of the things I believe in what he taught is work plus desire equals success. Work plus desire equals success. And that's what he preached. To me, I take a variation of that, and we talk about that. But I also tell them what I tell my trial students. If you want to make excuses for why you don't succeed, because someone else is smarter, prettier, funnier, better connected, more powerful. I mean, there's a million reasons why you could fail. But the one resource we control more than anyone else is our hard work. And there's no excuse for why anyone should ever outwork you. And I believe that as a lawyer, and I preach that to them as a lawyer. Okay, you're more clever, you've got more money, the other side has more powerful friends, they're going to try and derail this. But at the end of the day, I'm going to outwork you. And if you're going to outwork harder than you've ever worked in law school, then you're likely going to find success. And that's what it takes. And if you're not prepared to put the work in, then you're not likely going to find success in the legal field, because that's really is what it takes to get to the top.
Well, that is motivating. I feel motivated even though I don't have anything to work on. I'm going to find some work to do today. Dean Michael Coyne, thank you as always, and you enjoy the day.
Bradley.
Take
Thanks,
care.
Bradley.
Bye, folks. I'll talk to you soon.